Welcome back to the China Law 101 video series. I'm your host, Edgar Choi from Law in a Minute. In today's video, we will talk about what happens if a company fires a pregnant woman. According to Article 42, Item 4 of the Labor Contract Law, it is generally not permissible for employers to terminate the labor contracts of female employees during the pregnancy, childbirth, and lactation periods, also known as the 3 periods. This means that non-fault-based terminations and economic layoffs are strictly prohibited during the sensitive period. Therefore, any attempts by employers to reassign, reduce the salary, or directly dismiss a female employee during the 3 periods would be considered illegal termination of the labor contract. In the unfortunate event that a female employee is unlawfully dismissed during the 3 periods, she has certain rights and recourse available to her. Firstly, she can seek reinstatement to her original position, requesting the employer to revoke the decision or notice of termination of the labor contract. However, it is important to note that in practice, some courts may find that the lack of trust between the parties involved in legal proceedings can hinder the continuation of the employment relationship. In such cases, the court would confirm the illegality of the termination, and the employee can separately claim compensation for the illegal termination. Alternatively, if the labor contract cannot be continued, or if the employee chooses not to continue working for the same company, the employer is obligated to provide compensation. As per Article 87 of the Labor Contract Law, the employer should pay double the amount of severance pay to the employee. In other words, if the termination is deemed illegal, the employer must pay the employee twice the amount of severance pay as a form of redress. Now, let's address the question of whether an employee should be entitled to receive wages for the 3 periods if she is dismissed unlawfully. It is important to note that the labor contract law does not provide specific regulations on this matter, leading to different viewpoints in practice. One viewpoint suggests that when the contract is not continued due to an illegal termination and the employer has already paid severance pay, there is no future obligation to pay wages for these 3 periods. On the other hand, another viewpoint argues that when the contract is not continued due to an illegal termination, it is considered a mutual agreement between the employee and the employer. However, the termination is considered to occur at the legally prescribed time, which extends until the completion of the 3 periods. During this time, the employer should pay wages accordingly. If the 3 periods are completed but the labor contract has not yet expired, the employer should still pay for severance pay. Thank you for watching today's video. Please feel free to share your thoughts in the comment section below. Stay tuned for our next episode where we will talk about the process of registering a patent in China.